Good evening, everyone. It is very heartening to see a full house on a hot afternoon in the month of June, that too for a workshop on a niche topic on damages in construction arbitration. That shows the interest in the subject, that shows the development that Indian economy is doing, the steps that the government of India is taking. In fact, nearly $2 billion worth investment had come last year from in form of private equity and venture capitalists in the infrastructure industry. So if the statistics are to be believed released by the government, in 2025, India would be globally the third largest infrastructure sector economy in the world. So there is no doubt that construction industry and infrastructure industry is at its peak at the moment, and therefore NPAC, the guidance of Professor Douglas Jones and Professor Janet Walker, decided to host this workshop today for all of us. We are privileged to have three very distinguished speakers. I would give a very brief introduction of all the three speakers because the material that you has the detailed introduction of all of them, and in any case, I think neither of the speakers requires any introduction. To begin with, I would introduce Honorable Mr. Justice Deepak Mishra, former Chief Justice of India, who all of you are very well versed with. You've all read his judgments, used his judgments in doing your cases before the High Court and before the Supreme Court. His Lordship was the 45th Chief Justice of India, who had a long stint as the Chief Justice of Delhi High Court as well as the Chief Justice of India. He is now intensively involved in arbitration work. Many of his landmark judgments, such as TRF, Hardy Exploration, are very often used by construction and arbitration lawyers every now and then. We also have Professor Douglas Jones, who is a leading international independent arbitrator who's been doing commercial, investor state, construction arbitration across 30 jurisdictions. One of the leading figures in construction arbitration, as I would recall from my first introduction of Professor Jones, and he's been widely published and very well regarded in the industry worldwide. Although India is not a jurisdiction which is new to him, some of us have had the privilege of hearing him at conferences in India, including the Society of Construction Law Conference and a couple of other events in the recent past. So we again have the privilege of hearing him today on the topic of the presentation. We also have Professor Janet Walker. She is one of the leading arbitration experts from Canada. Again, her work is split into three prominent jurisdictions, Canada, United Kingdom, and Australia. However, she sits as an arbitrator, as a chair, and as a co-arbitrator in different jurisdictions around the world. She's also the vice chair of ICC in Canada, and again, a professor of law. Professor Douglas Jones and Professor Walker would be giving a joint presentation. But before that, we have the privilege and honor of having Honorable Justice Deepak Mishra, who will give us the opening address on the subject. Thank you, sir. May I welcome you on the, maybe if you would like to use the mic here or the podium. Thank you, sir.
Professor Jones, ma'am, Walker, Mr. Garg, ladies and gentlemen. I think the entire introduction of mine was wrong. I'm not going to give opening address with regard to the topic they are speaking on. Mr. Garg met me and told that I have to speak on the Indian perspective. In this context, I'll tell you two episodes, then I will speak on certain Indian aspects. First, there was an English author who said, I can resist any temptation except temptation. Context was different. Temptation is to hear the learned speakers who are experts in the field And that's the temptation what drags me here in the summer afternoon. I think I can include all of you in the same category. Second, we had a Chief Justice of India in 2010. I don't have to say he's no more. He had to attend a conference, a tax conference. So I thought the Chief Justice of India would inaugurate and get up, go away. I was in the Delhi High Court. Then he said, I'm staying back. I said, sir, why should you stay back for the whole day? That much courage, I have to ask him that question. He said, I have contracted myself with my intellect. I've included me in. Okay, I could answer further, but I had a very good mind to say, sir, you should have included yourself out. And I am not including me out from learning. I've come here, and I must have said with you, I should have been sitting there to listen with respect, listen with curiosity, listen with intellectual temptation. I'm here. See, let's go back on a time machine. The year was 1978. We didn't have 1996 Act remotely, the concepts remotely. Question arose, if a particular contractor has done certain extra work, would he be entitled to damages or the payment of money? Because the clause clearly stipulates the money shall be paid for the work and nothing else. This judge was a bright judge, interpreted. When you talk about work, that's an additional one. That's an ancillary one. You gave the work as the owner. So extra work is a part of that work, though it's called extra, and therefore the arbitrator is justified, is granting the money and the compensation. The award was upheld. And eventually they came to Supreme Court, nothing happened here. And the beauty of those awards, which none of you might have seen, I don't include the old people, they will write, narrate the facts, and how many witnesses have been cited, and thereafter they will write, I am satisfied that the claimant is entitled to so many lakhs or crores of amount. Nobody interfered. The Bible was 1923 Privy Council that you can't enter into the mind of the arbitrator, and he is the chosen man by you, and therefore question of interference by court doesn't arise. But that was a different kind of period. Now every award can be of scrutiny, and that many hours are taken before the arbitrator to argue on facts as well as on law. And the construction arbitrations on construction contracts, in the Indian perspective, what emerges are basically, I'm yet to face that in the proceedings as an arbitrator. I'm talking from judge's point of view in a different way. Whether it has some kind of a rationality. I'm not using terms of the Contract Act now. Whether it has some kind of rationality. When you pose a question, whether it has some kind of rationality, it will include itself in a sense of commonsensical reasonableness. The moment you utter reasonableness, it must have the conception of objectivity. Now, how do you really judge objectivity in a construction contract? You are not always in a position to judge objectively on facts. When I am using the word objectively, I am not saying independently or impartially, but which are based and founded on facts. Supposing it's not founded on facts or evidence, is the person deprived of grant of damages or compensation. The courts in India, therefore, interpreting the provisions, laid down many principles. First, if the parties at the time of entering into the contract had genuinely believed and estimated in the event of breach there will be so much damages, and in that calculation there is no dominance, the court should accept it as a reasonable one, as a rational one, and should not interfere in that kind of an hour. Second, how do you really understand it's a genuine estimation or it's not? You see, everywhere the courts have said penalty and liquidated damages. The position, you understand, is not the word used. The word used is not a categorical decisiveness. You have to understand the surrounding circumstances, whether it has the nature and character of penalty or liquidated damages. Then you have a role to assess. You can't have the flight in fancy. Stipulation is you are required to grant reasonable compensation or damages. In our system, there are three concepts. One, you can't speculate, but you can conjecture. I'm using it as a verb here. You can't speculate, but you can conjecture. And in the conjecture and speculation, there falls a word which is some kind of different shade, guesswork. Now this guesswork, how do you do really guesswork while granting damages? Mr. Garg will have kind of guesswork. He said this guesswork is the correct one. Mr. Panchanand, if I'm pronouncing the word Tom, the surname correctly, he will highlight, no, this is not the proper assessment of the guesswork. The assessment has to be in this way, which falls in the realm or sphere of guesswork, and therefore do it. There I would like to suggest that guesswork must be perceived on some kind of first principles which fall in the realm of contract. And that has to be really appropriately understood. Now when you grant damages, universally various factors are taken into consideration. Like supposing there is a particular area of contract, a design given in a construction, a structure given, a change takes place, what we call the change in scope. When there is a change in scope and the contractor suffers, or the party suffers, the beneficiary suffers, whoever it is, or there is a change, then question of compensation may arise. In that arena, one has to really adjudge what is the effect of the change, what is the effect of the change in the design, what is the consequence in the change in the structure. So many technical aspects have to be gone into as far as it's concerned. You see, delay, all of us have granted damages for delay. And I would go 24 years back, are good for compensation when there is delay. Then there has to be some kind of, I would like to use the phrase, uncommon, commonsensical approach. I do not know whether the young students would understand this uncommon common sense. Uncommon common sense doesn't mean it's beyond common sense. It means it must have some perceptible common sense, a perceivable applicability of grant of damages. And you must weigh what are the causative factors for such delay, the responsibility and the quantification. And therefore the concept is, first, fix who is liable to pay. Second, who is responsible for the delay. Third, quantify. The steps and the procedures are to be understood in the uncommon, commonsensical manner where there are guidance and guidelines. Sometimes what happens in this kind of contracts, there's an extra mile the owner tries to take and sometimes the contractor tries to take. You have to judge on the facts and the evidence who has really tried to take the benefit of this contract in a different, beyond the contract, by putting certain conditions. The imposition of condition and acceptance of condition is not the ground. The ground is, even if there is acceptance, what is the ultimate secutor? That you have to judge, that you have to see. And as a lawyer, when you really argue before an arbitrator, that should be the way you start with, not any kind of, if I am permitted to say so, with hyperboles. Arguments with regard to damages and compensation are to be based on rational principle, not on hyperboles. I recently spoke somewhere. Argument was, the question was, I am not taking any questions will be taken by both of them. Don't you worry. While posing to somebody said, sir, in particular judgment, the Supreme Court interpreted it wrong. It was absolutely unambiguous. Why did the court say it is penalty? I said, dear one, it's very easy to find faults with the judgment. I'm not saying that you can't. Every one of you is entitled to criticize, a constructive criticism. But have you really read? Was the clause unambiguous or left some ambiguity? That you have to scan the clause. Have you read paragraph so and so while the clause has been analyzed? Read it. I saw to it that the said clause was read. So that tilted towards ambiguity in a different way. And you have to really understand the anatomy of the phrase used in the clause and then decide. Understand. So this is quite a interesting field, not a prosaic field. Understanding damages in construction field is poetry. When I say poetry, in contradistinction to prose, pleasure in contradistinction to ennui or boredom. Now I'll conclude by reading two lines. I've got a written paper. I'll give it to Mr. Garg if he's, I don't know that he can to circulate, he can. Thus, from the Indian perspective, the broader spectrum has to be kept in view. The principle that there should not be a windfall or labor in vain should also be oppositely perceived in the process of adjudication. We are here to learn, and the process of learning commences when we are determined to abandon notions and get wedded to principles. Please abandon your notions and get married to understand the principal perspectives of the principal causes of damages. I'm here along with you, only sitting there, but to learn. I've come here to learn as a student, and I'll go back here, from here, as a better student. Thank you. Thank you very much.
Thank you, sir. That was very informative. I would now like to invite Professor Doug Jones and Professor Janet Walker to present on the topic of our workshop today, damages in construction arbitration.
Thank you. Thank you very much. Thank you for those opening remarks. It's a great pleasure to be here this afternoon. The opportunity to come to India for me is always welcome, even in the summer when I'm here for an arbitration about to commence tomorrow. And it's also a great privilege for NPAC to have decided to support this seminar. The work that NPAC does, I am already aware of, and it makes a great contribution as an organisation to the development of arbitration in India. So we're honoured to be part of this process. Professor Walker is now going to outline what we're going to talk about. And from that outline you will see that we intend to speak a little bit more broadly than just damages in construction arbitration.
Thank you very much, and thank you for that very warm welcome, and for the privilege of listening to you, sir, in your wise remarks at the beginning. We will now move through 6 topics quite ambitiously over the next, remaining time that we have. Professor Jones and I will sort of trade off so that you have an outline of where we will be going today. We will begin with a discussion of bifurcation and where the determination of damages fits in the overall process of the arbitration and why it matters how it fits in a particular place. We'll then talk about the use of experts in the quantification of damages and how they can most effectively be managed so that they will be of the most help to the tribunal. We'll then turn to a brief look at the different kinds of damages that can be awarded in arbitrations and why we need to be aware of how those differences apply in different legal systems. Because of course arbitrations are very international, and one day you may be sitting as an arbitrator hearing a case with under Singapore law, and the next week you may be sitting in a case where the governing law is India, and so you might need to be aware of the way in which the Indian law conceives of damages and how it applies them. Finally, we'll turn to 3 industries, not merely construction, but say a little bit about each of these 3 industries: energy and natural resources, mergers and acquisitions, and finally we'll get to the grand finale, construction law. So turning to the first topic, that of bifurcation. As I said a moment ago, it matters a great deal where the damages and how the damages are fitted into the overall process of the arbitration. Many lawyers who grow up learning about law by reading legal decisions focus on the reasons for judgment. So much of that has to do with determinations of liability. Who has a right, who has an obligation, who is correct, who is wrong, who will win and who will lose. And only after that is that question of damages considered. So we tend to think of our work as focused on the liability issues. And indeed, I might mention, if I dare say, that many of us lawyers have some difficulty with numbers. We are people who deal with words very effectively, but not always so well with numbers. So we tend to want to sort of put that aside. And you see, therefore, in many arbitrations, a great tendency to want to divide the 2 issues in half. Let's talk about the liability. Let's talk about the merits of the case. Let's talk first about who will win and who will lose. And having then resolved all of that, we then turn to the question of damages. That can work quite well in a court of law. but often it can create challenges within an arbitration. And in part that is because the arbitral tribunal has a mandate to manage the case from the beginning to the end, and it tends to keep the interest of the parties only if it wraps everything up together in an effective way and doesn't leave the process hanging in the middle, only to be determined later. So if you bifurcate a case, if you say, let's talk only about the merits, and then later we'll think about how we plan for our determination of damages, and not have a procedural timetable that stretches all the way from the beginning to the end, you could find yourself in a situation where you have determined liability. One side says, I win, the other side says, I lose. And the losing side is suddenly very busy and not very available to complete the arbitration, and you have a great difficulty finishing it. So it can often be a challenge to bifurcate merits from damages. Beyond that, I just want to clarify, as it says in the first point, that there are a whole variety of other issues, preliminary issues, issues of the tribunal's jurisdiction, issues of the admissibility of the claim, issues of arbitrability, issues of joinder, who are the proper parties. All of those may be very discrete issues, issues that actually might be dispositive of the entire claim. But it can be often very effective to work those issues right into as an integral feature of the entire procedural timetable, so that people are working towards a fixed main evidentiary hearing at the end, one in which, in fact, ultimately, all of these issues are completely decided. And if the early issues are decided along the way and the arbitration finishes, that's fine. But you continue all the way along toward merits and ultimately damages. I'm turning it over to Doug now, because he's going to speak about how the quantum of damages can be related to the merits.
As Professor Walker has said, there is a strong seductive influence for arbitrators and for lawyers to leave damages to the end and hope you never get to them. If there's no liability, we don't need to deal with damages, is a common thought, indeed submission. Now, sometimes that is necessary, as Janet will come to in a moment. But almost inevitably, in any case, particularly involving infrastructure disputes, the temptation to put off damages is strong. And one party will, of course, always have a tactical interest in doing that. From a tribunal's perspective, though, one of the things that I have found is that the evidence relevant to damages often is very persuasive on the issue of liability. And if I give you a simple example of a case where there was a very substantial dispute at the commencement about whether damages would or would not be bifurcated, you'll see what I mean. This was a case involving the failure of a large number of monopiles in a North Sea wind farm. You know, there's a lot of windmills in the North Sea, and it's part of the Green Energy Initiative of Europe. Well, a lot of them started failing, and I won't go into the story behind that, but the case that I was chairing involved the question of liability for the failure of these monopiles, and there was the inevitable question of the costs of rectification. So the submission was, let's decide whether there's any liability as asserted, and we can leave the question of the cost of rectification to look at if we need to. Now, we decided as a tribunal at the outset not to do that. And at the end of the case, we were so grateful that we'd made that decision. I mean, a lot of decisions you make are evenly balanced and you aren't quite sure whether the outcome is going to be the correct one. But this was so right, because the evidence going to the quantum of rectification dealt with how the rectification was to be done, logically enough. And in that evidence, we had so much material which enabled us to decide whether the design was inadequate and whether the workmanship was inadequate, that using that evidence to decide liability enabled us to reach a much better decision on liability. Just an example, there are many other cases that I have where the temptation, if resisted, actually produces a better outcome on liability.
And one final point on bifurcation, and that is the opposite side, the exception to the rule. Sometimes you have a case where the legal theory of one side is completely at odds with the legal theory of another side. I had a case recently like that in which one side was arguing a contract claim, the other side was arguing a defense based on corporate law, and they just sort of couldn't mix. They were oil and water throughout the entire proceeding. Well, one of the questions was, should we form a complete path toward the end that included a determination of damages? But the answer was, if we'd done so, we would never have been sure whether the principles, whether the approach to damages would have been a corporate law one or a contract law one. And it would have involved an entirely different approach, perhaps different experts, perhaps certainly different quantification methods, and to begin to prepare all of that material in advance, not knowing which you will be then working with, was something that would have been a lot of wasted time and effort. So although we slotted into the timetable our anticipation for when we would need that, we didn't then begin that process early on. It was a kind of a bifurcation, but it's just to show you that there are many different ways of doing it, and the way you do it can affect the time and cost it takes to determine the damages and indeed the overall result. Turning to our next topic, that of the use of experts, because of course they are often the most common place in which we need experts, is the determination of damages. And I'll just leave off on a few brief points on the question of whether you have tribunal or party-appointed experts. In the common law, we almost always have party-appointed experts. Quite rare to have a tribunal-appointed expert. Very difficult in an adversary system, especially in a court of law, for a judge to be able to anticipate what questions would I ask an expert. How would I know, what the material is that I should engage them in to produce a report. So they rely upon the parties to produce experts. Having said that, the challenge for common lawyers is that over the years, recently, especially with the move to civil justice reform, trying to improve time and cost in dispute resolution, we've been aware of the fact that experts who operate like hired guns often do more to slow the process than they do to advance it. The interesting fact about international commercial arbitration is that somehow, for some reason, even civil lawyers, even lawyers from civil law jurisdictions in international arbitration seem to have caught the bug of party-appointed experts. And so although they are very used to having tribunal-appointed experts in their own courts, when they come to international arbitration, they then often want to and embrace the idea of party-appointed experts. So the challenges for arbitration are very similar to the challenges that we've faced in the common law. How to take two party-appointed experts and make them work together well enough that they can be a real help to us as arbitrators. I'm going to turn it over to Doug.
The concept that an expert appointed by the lawyer for a party and paid by that party should actually be independent and serve the tribunal with honest and independent views is something which many counsel find quite difficult to grasp. Indian advocates are amongst the best in the world, but they do have a adversarial process which would find the concept that their expert should actually work for the tribunal just a little bit challenging. It's the concept of loss of control. Now, there is nothing more wonderful to behold than an American lawyer faced with the loss of control of their expert, because they, of course, do a lot of their commercial dispute work before juries in the US. And in construction cases, the majority of those cases domestically that are not in arbitration are decided before juries. So there, of course, the high watermark of counsel finding the concept of tribunals taking the experts to become their assistants quite culturally challenging. However, that is the concept. Party-appointed experts are meant to be independent. And I see here tonight some experts who will no doubt agree with me that the limitations upon their capacity to assist tribunals imposed by the adversary system mean that they are not able often to fully deploy their expertise for the benefit of the tribunal. Now, it's a topic all of its own which we could spend all night and all day on, and one dear to my heart because I have found that where one can work proactively with the party-appointed experts within each discipline, there is true value available to the tribunal, a value which is quite different to what is often the case where party-appointed experts each present their party's case and often pass like ships in the night, answering different questions, producing different outcomes. The capacity then of tribunals is merely to say, I prefer expert X to expert Y, that's what I'm going to take. There is no capacity to achieve value from both experts. Sometimes, of course, tribunals say they don't accept either expert, which is a difficult scenario for the tribunal. So, the principles that I would like to leave you with, to think about, and which have been the subject of other presentations that I have done here in India, is that experts of like discipline should at least answer the same questions. Questions which are ultimately settled by the tribunal in consultation with the parties and the experts. And they should work from the same data set. There should be a common data set upon which they work. Once those principles are accepted, there can then be proactive case management leading up to the hearing between the tribunal and the experts. And just as an example of how this can be so productive, I completed a case recently involving well over $1 billion involving the construction of a nuclear power plant, where there was very significant dispute about a whole range of things, including the effect of delay on productivity. That was a disruption claim. Now, for many of you involved in construction disputes, you will know that calculating disruption can be one of the most contentious areas for experts. After a long proactive case management process with the experts appointed on disruption, and we had 10 other expert disciplines, apart from disruption, giving evidence in this case, the experts, just prior to the hearing, told the parties and the tribunal that they had agreed on their methodology for calculation and upon their calculations of disruption. So the hearing proceeded on the basis that both experts jointly presented their findings to the tribunal and there was no cross-examination. There was a bit of nervousness from both sides because the answers that the experts came up with didn't really make both sides happy. But it was the view of those experts, and it was really an extraordinary example of how this can be done.
Turning to the next topic, that of the different categories of damages, this will all be very familiar to you in many respects. The point that I want to emphasize here is when we're speaking about compensatory damages, compensation for loss, it can make a difference which law applies. It's true that generally speaking between the common law and the civil law and many of the legal systems within them, that the principle of full compensation, or in contract law, we might speak about it in terms of expectation damages, prevails across legal systems. But there can be subtle questions on the margins, questions about whether you must also show fault in order to recover on contractual damages, questions about whether there's a duty to mitigate, questions about whether the damages need to be foreseeable. Some of these principles might exist in one law, but not in another. And so although we may think, my goodness, now we've come to damages and the only challenge we face is the numbers, you can actually have other questions that precede that, questions about how you approach certain kinds of damages. So that's in compensatory damages. I'm going to turn it over to Doug to speak about the effect of the parties' agreement upon the kinds of compensatory damages you can receive.
Often in contracts, including particularly in complex agreements involving infrastructure projects or in resources-based projects, there will be some very specific contract provisions dealing with damages. There will almost always be some restrictions upon recovery of damages, because the balance of the transaction will mean that neither party or one party is able to take the entire risk of potential damages associated with breach. So therefore one sees provisions which limit recoverable damages to concepts like direct damage as opposed to indirect damage, or which exclude liability for consequential damages. Now those contractual provisions, limiting as they do what can be recovered, are, as you would expect, the subject of fierce debate in proceedings where those limitations are sought to be deployed by a party from whom damages is sought to be recovered, and by those who seek to overcome that limitation. And the interpretation of the contract about which we have already heard will be closely relevant to the effective right to recover damages within those areas of limitation. There are also often monetary limits upon damages that can be recovered due to the immense potential liability that might emerge from a particular contract. So, just to take by way of example, the design, construction and commissioning of an offshore oil and gas platform could, you would easily understand, lead to enormous potential loss upon breach of particular aspects of that contract, and therefore it is common that usually in addition to limitations on indirect and consequential damages, there will be a limitation expressed sometimes by an absolute amount of money or by a percentage of the total value of the contract that would limit the amount that can be recovered. But there is often in those provisions which say that there can be no liability exceeding 5% of the contract sum or the like, escape clauses, such as except in the case of gross negligence or willful misconduct, or phrases like that. Now those, again, are provisions which lead to the need for careful analysis of the contract. I've just finished a case at the moment in Canada where we did actually have a bifurcated proceeding about whether there was gross negligence or not, because the limitation on damages, the percentage of the value of the contract that could be claimed as damages, the difference between that and the amount of the damages sought to be recovered was $2 billion US. So the debate was, has there been gross negligence? Well, that's a factual question, but it also turned out to be quite an interesting legal question. What is gross negligence? We in fact held it wasn't a concept to be found in the law of tort, but was a contractual concept of very bad breach, as opposed to which represented a tortious liability. So those are very interesting questions which often arise in compensatory damages. I'm going to come to the issue of liquidated damages, already raised by Justice Misra when I deal with infrastructure damages.
So turning to what's labeled here as non-compensatory damages, other forms of relief rather than compensatory damages, there are a far more interesting variety, and these can be can have quite an effect on the determination of damages themselves. As you know, in the common law, specific performance is the exception to the rule, the requirement that you perform a contract, or the requirement that you do a specific thing, or refrain from doing a specific thing, rather than granting a monetary award, is the exception to the rule. And in theory, it's not the exception to the rule, it's the reverse in the civil law. But in arbitration, and this is the point for us today, specific performance can create special challenges. And that is because, well, for two reasons. One, we have no powers of contempt. We can make monetary orders, and I guess in a sense we can fine parties, but we can't put people in jail. So we don't have a lot of powers to enforce specific orders. The parties would have to turn to the courts, but far more significantly, specific orders often require some sort of supervision, some sort of oversight to ensure that they are performed. And this may well carry on into a period when the tribunal no longer exists. Because as you know, unlike judges in courts, when our final award has been issued, subject to a small period of time in which there might be corrections, usually a month, we are no longer. So there is no one to supervise the specific order. So specific orders can be a special challenge for arbitrators. Nominal damages. Nominal damages are another kind of damage where you haven't seen any proof of loss. They're sometimes described as a hook to hang your costs awards on. You say, yes, I see that this party has suffered a breach, but has not been able to demonstrate loss, but nevertheless is entitled to its award of costs. So you may award a nominal sum for damages. As Doug was mentioning earlier, there can be, larger damages for gross negligence, and sometimes there can be what's described as punitive damages and exemplary damages. This is something that is far more common in the United States. It does exist throughout the common law. It exists in only very subtle and slightly different forms in the civil law. But the important part with this is there is a huge debate around it. And debate in part because this award is making an example of the losing party. An example for whom? is this not a private dispute? This is a contract matter. Even where exemplary and punitive damages are available, sometimes they're ruled out of commercial disputes and contract disputes. So it's quite controversial. The last point on punitive and exemplary damages that I want to make is that it can sometimes create issues for enforcement. Just as the awarding of interest can create issues under Sharia law, so too can the awarding of punitive damages sometimes create problems for enforcement. So an arbitral tribunal needs to be very mindful of what the parties are asking for in their prayers for relief, and of the places in which the award might ultimately be enforced. There are also two other kinds of damages. Moral damages. Sometimes in the common law we describe those as general damages. They can be damages for non-tangible things. You know, typically we see them in personal injury cases for pain and suffering. But do they have any real place in a case in which the parties are both corporations? Well, more recently there have been issues raised about, you know, corporations and their goodwill, their reputation, you know, their creditworthiness with banks. Should there not be some compensation for harm that is suffered in that sort of way? So moral damages are something to be on the lookout on the horizon in the future. But I also did mention already the question of enforceability. So I will turn it over to Doug to speak about the first of our industry-specific types of damages, and that in energy and natural resources.
A topic highly relevant and dear to the Indian economy. So I thought some comments about the calculation of damages in the energy and natural resources space might be relevant. And what I wanted to look at is some of the issues which emerge in the calculation of damages associated with claims for breach of contract in energy and natural resources project agreements. Firstly, some key valuation issues, particularly in extractive resource matters, oil, gas, mining, and the like. The first is the size and nature of reserves. The amount of economically extractable reserves is obviously a key issue in the calculation of damages and a major matter for expert evidence in these cases, with the distinction clearly obvious between proven developed reserves and proven undeveloped reserves, which exist but have not been developed. What price for the future is going to be applied to the calculation of valuation for the purpose of such reserves? Market-based data, well, that tends to be a little immediate for a calculation intended to cover a long period for which enjoyment of the benefit of the agreement has been foreshortened. The models of future supply and demand are clearly an issue of some considerable dispute between experts and also between the parties who, on the one hand, hold the reserve and the other who are seeking to exploit it. Contractual, regulatory and country-specific risks are also relevant. Firstly, upon projected contract length, and then upon the effect of country-specific risks on changes in policy, particularly relevant to changes in policy regarding taxation and exploitation and legitimate changes in royalty structures. Not just issues related to the foreshortening of a concession, for instance, by legitimate government decisions. And of course, the legal theory of the case developed for the purpose of valuation is relevant to whether you have an ex post or an ex ante valuation exercise to undertake. And then when you come to calculation of loss of profits, the methodology to assess damages can become even more complex. The income approach is a common approach generally accepted as relevant to this sort of calculation, with the discounted cash flow method the most common methodology used. But there are others which will be advanced by parties seeking to maximise the opportunities for calculation of damages, including a relative multiples approach as a potential approach, which is an expression of the market value of an asset relevant to a key statistic such as EBITDA, revenue, asset value, or size of the reserves, and which seeks to standardise the value of the asset. And then there is a stock market capitalisation approach, which seeks to draw upon the value on the stock market of the particular entity, or an entity which is said to be comparable. They represent, in the energy and natural resources space, some very complex issues with which one needs to grapple as an arbitrator, because they will undoubtedly be the subject of competing contentions by the parties and the experts. Now, it's also important to remember that the remedies for breach in the energy and natural resources space are not just damages. They can be forfeiture. Say one has an agreement for a joint venture to exploit a particular oil resource. There is normally contained within a joint venture agreement for the exploitation of such a resource the appointment of the operator. And the operator has certain rights to spend money within a framework agreed for a period of time, and to call for contributions towards the cash flow associated with that development. And it is common for the remedy for failure by partners to meet calls for contribution to the costs within the budget to forfeit the interest in the resource. And the arguments associated with forfeiture, when sought to be enforced, involve a whole range of issues which bear on the question of penalty and liquidated damages, which I will come to in a moment in the context of construction issues, but which has been the subject, of course, of some very recent discussion in the Supreme Court of the UK and in the High Court of Australia regarding the theory of forfeiture as part of the common law of damages. And it's important also to recognise in the energy and natural resources space that price adjustment disputes are not damages. And there are many cases of price adjustment for the value of resources, oil, gas, hard rock mining resources and the like. Those price adjustment provisions are there because there are long-term agreements, and how to calculate the increases in price are a quite separate exercise to damages, but very numerate, heavy.
Turning to the field of M&A, can I just pause to ask, who here is an accountant or who has studied accountancy. Is there anyone here? One? Good. I'm going to invite you up here to give the next presentation, only because, as I say, as lawyers, we are often most anxious about the numbers, and certainly M&A disputes are very numbers intensive. Just in a different, slightly different way from construction disputes, but in a similar way, they can often involve very different kinds of disputes that are all discrete in their own way, but very much interlocking one with another. So sorting them out and structuring them can be one of the great challenges. Definitely using quantum experts effectively can be so important. To use them well, you need to have very sound case management techniques, but you also have to know a little bit about what they're doing. Otherwise, the risk is that the most confident one will prevail, not because he or she is right, but just because he or she seems more persuasive. So having said that, typically the heart of M&A disputes are the price adjustments, so that you know what's going on with that. A company is valued at a certain point and will have a whole series of factors, perhaps a net debt, net working capital, investments, capital expenditures, off-balance sheet items, and create a whole table upon which they agree upon a number, a figure to buy the company for. But they do that on day one, and when the actual closing of that transaction takes place, perhaps a month later, 2 months later, even longer, all of those numbers can shift around. So how do they manage that? Well, there are different ways of managing it. They can choose an arbitrary date shortly before the closing and agree on that date and then run all of the numbers again. Or they can have other sort of mechanisms for doing it. But reconciling those in a way that makes both parties comfortable is a critical factor, because you can find huge swings depending on how many receivables you've collected in, how much other investment has gone out, whether you've just made a major tax installment payment. All of these things can have a factor upon, where your working capital lies at the actual date of closing and how it differs from the date on which you signed your contract. So the parties need to agree upon that. When they don't agree upon that, that's when you may find yourself in an arbitration. We might have to sort them out. Just a little sort of light at the end of the tunnel so you know what I'm talking about. If you manage your experts very well, then what you might ultimately get them to do, and this is what I was very pleased to do in one arbitration, was to produce a spreadsheet at the end where there were a whole bunch of little boxes where the tribunal could say, yes, we agree on this issue, quick, an agreed number. No claimant loses on that issue, an agreed number. Is the answer A, B, C on this issue? The answer is C, and the experts had agreed on a number. So they created a spreadsheet for us, and I have to tell you, a calculation that I would never have been able to do in months and months and months of time, and that they could never have been confident that I would get right, even after months and months of time. It took me about 15 minutes. Because having agreed on the issues in principle as lawyers, I was able to say, do, and in the end, it all came out with numbers that I knew would be numbers consistent with what the parties expected and what their experts had agreed. So ultimately, that's what you aim for. Just to say, one of the things that can be also very challenging is that within these small differences, depending upon a valuation issue, which Doug was speaking about a moment ago, if that valuation issue includes a multiplier, a small difference in one of these factors, or in the outcome of your price adjustment, can create a vast difference in damages, can create a vast difference in the ultimate outcome, depending on the multiplier you're using or depending on the approach you're taking. I won't take up any more time except to say, yes, of course, just as in energy and natural resources, you have differences in approaches that experts might have between whether you're using a market approach to evaluation, an income approach, that's a discounted cash flow approach, or whether they're also using some kind of other approach, like a replacement, the cost approach. What would it cost to replace what we otherwise don't have as a result of the breach? So that's kind of a very tiny snapshot of M&A disputes and calculating damages, but it shows you what kinds of issues might arise and how it's important to manage the experts well.
I guess, Janet, it might be that in the context of M&A disputes, one might see examples of where bifurcation of the question of damages is essential. I recall a case, it actually looks like it's just settled, but it was a dispute between two private equity companies over a Korean asset, which one of them had agreed to buy from the other, but then got cold feet and purported to terminate the M&A agreement. Now that the complexity of who terminated validly led to enormously different outcomes of calculation of damages, because if the purchaser had validly terminated, there was a whole different sort of damage to be claimed than if the purchaser purported termination turned out to be invalid. Because in that context, interestingly, to take up the point you mentioned earlier, the primary remedy for breach under Korean law is specific performance, not damages. And so we did not proceed to the damages question until we had decided who was correct in the termination context, because it was so different an approach.
And indeed, Doug, you're quite right that not only was it the case in that particular instance, but it has been the case in some of my M&A disputes, that yes, the price adjustment is often at the heart of the debate, but it may not be the only dispute that arises out of a post-M&A matter. You may well have obligations to third parties, or perhaps the asset that has been transferred, the company that's been transferred is in difficulty, and who should be responsible for that liability to a third party. So all of those other issues can surround the price adjustment issue, and indeed you sometimes see in mergers and acquisitions, in share purchase agreements, you sometimes see the question of price adjustments hived off as one to be determined by the accountants and not brought to the lawyers at all in an arbitration. So these things can raise damages in many different ways.
So
infrastructure.
We come to infrastructure, which is what you all thought you were coming to hear about. The first issue I wanted to talk about was the one which Justice Misra raised in his opening. Section 74 of your Contracts Act. Now, as many of you may know from a comparative law perspective, your Contracts Act is not the only Contracts Act which which Britain imposed upon the colonies. Malaysia has a similar provision, as does, I've discovered, in another arbitration, Tanzania. And there may well be other relics of the British Empire elsewhere in the world with Section 74. Section 74 impinged upon my consciousness when I was arbitrating a dispute between a Canadian owner and a Korean contractor over an offshore oil and gas production facility in the South China Sea many years ago. for some reason which never became clear in the case, the parties chose Malaysian law to govern the contract. Malaysia had nothing to do with the contract. It was being built mainly in Vietnam and then assembled and commissioned in international waters. But there were, as you might expect, allegations of delayed performance and a claim for liquidated damages, to which the defence contained in the reply to the notice of arbitration, you've got to prove them, to which the lawyers acting for the Canadians said, what do you mean? They're liquidated damages. We want a preliminary decision that this is rubbish. There was silence for a little while, and then both parties came back and said, oh, we accept that under Malaysian law you have to prove your damages up to the limit because of the Contracts Act. And then, of course, there was a bit of an issue because this was a case done in a rising oil market, not like we have at the moment, but this was a massively increasing oil market. And the argument was, well, you're pretty lucky you got it late because now you're going to be able to make more money than you would otherwise have made, so you've suffered no damage. Anyway, that is not, I think both those parties will think again very carefully about their choice of law before they put a choice of law in an international construction contract. But that impinged on my consciousness, and so when I came to be arbitrating some disputes under Indian law, I looked with interest at the Indian Supreme Court authorities, which were quoted as having been adopted by the Malaysian courts following the Indian Supreme Court decision. And I have watched with interest the development in Kailash, Nath and Delhi Development Authority in relation to some qualifications on the principle that liquidated damages might need to be established. Seems that the exception, and I'm not pretending in such august company to be expressing a view on Indian law, but there is an exception where the calculation is so complex that the amount provided can be recovered. But certainly the issue of liquidated damages for delay, particularly, which is where it most often is provided for under Indian law, is more complex than it is under most other laws. You should appreciate, though, that the question of penalty and liquidated damages having been subsumed a little bit, as I understand it, in the context of the Indian authorities on Section 74, is also a very interesting issue under civil law. Because under most civil law regimes, and particularly those which are derivations of the Napoleonic Code, there is wide discretion contained in the codes to adjust liquidated damages. Adjust them by reference to actual loss incurred post-breach. But there is less discretion where the amount specified is characterised as a penalty. Now, that turns on its head the common law concept of penalties and liquidated damages. And this is an area that is a trap for international construction lawyers and for counsel and arbitrators in international construction disputes. I've had some very interesting arguments in the Middle East, where of course Napoleon's invasion of Egypt has meant that the Code Civil is adopted in most of the Middle East countries, certainly the UAE, in Bahrain, in Jordan, and in Syria, and applications in major construction disputes for discretionary adjustment of liquidated damages provisions where either there is no loss or where the loss is wholly disproportionate to the liquidated damages provided for. So that area of liquidated damages is not just an interesting one under Indian law, it's interesting in a whole lot of other jurisdictions. And of course, you would be aware, as I mentioned a moment ago, that there has been a major revision of the concept of liquidated damages and penalties by the UK Supreme Court and by the Australian High Court, which have diverged a little. There is yet to be a pronouncement on the subject by the Canadian Supreme Court, but it is an area where there is fascinating developments within the common law, as well as quite substantial divergence in the civil law. The second topic I wanted to speak about was damages for termination. Now, in infrastructure disputes, the big ones tend to involve termination. Not always, but the biggest disputes are where there's been such a major breakdown in the relationship between the purchaser and the service provider that there's been a termination. And the concept of breach and damages for breach needs to be looked at in the context of the contract, because in most major infrastructure contracts, EPC, EPCM, traditional construction contracts, there are provisions of detail relating to termination. So if you take, for example, Clause 15 of the Red Book of FIDIC, which some of you may be familiar with, you will see a detailed regime for termination by the owner and for termination by the contractor, respectively for breach by the other. And you will find in those detailed provisions formulas by which there will be calculated the compensation payable arising from a valid termination by one party or the other, which means that there is effectively excluded from consideration questions of general damages for breach, because it is highly likely, and normally the case in my experience, that the termination will have been effected under the clause in the contract, and thus there will be an entitlement arising from that. Although, of course, if there is a termination which turns out, say by an owner, to be invalidly exercised, there will be some provision for damages for breach. Although you should be aware that in many contracts, arising largely from a development in US contracting practice, the remedy for wrongful termination is also a contractual remedy, because there will be provided in many contracts a provision that says that if the termination is unlawful, the compensation will be calculated by reference to the termination for convenience calculation provided for in the contract. So, damages for termination is a trap for young players in that it is not a simple gotcha for a breach provision, but is often a contractual calculation which needs careful application of the contract provisions. And that brings me to my next topic, which is damages calculations in infrastructure contracts often are not damages calculations at all. They're contractual remedies for compensation, because in the detailed contracts entered into for the provision of construction services, say, or for operational services after the completion of construction, there will be provisions which say that if something is done by an owner to the service provider by way of additional work, or by way of delay, or by way of interference, there is a formula provided in the contract which will lead to a calculation of compensation in that event. And the contractual remedies for compensation often sit uneasily with the general principle of damages, which would apply but for the provision in the contract which gives a specific detailed right to compensation in the event of delay, interference, variations, and the like. And that impacts heavily upon the, what shall I call, the traditional claims that are the subject of arbitration proceedings in infrastructure. Impacts upon claims for prolongation, which is just a shorthand way of saying I was there for longer than I thought I would be and it's cost me money, which is the contractor's reverse argument to the owner saying, you were late and I lost money, saying you delayed me and I lost money, prolongation. Prolongation as a method of calculation is complicated in its own right, because first you have to establish for how long was the contractor compensably delayed. And you may find in the construction contract that there is a limitation on the right to recover payment for delays caused to a contractor in circumstances where the contractor has not applied for and been granted an extension of time for the event said to give rise to the compensation. There is often argued a general right of damages for breach where the delay, the subject of the claim for prolongation compensation, has been done by an owner out with its powers under the contract. But because there are a lot of powers under the contract which an owner can exercise, that I mentioned a moment ago, which give rise to a right to extensions of time, the connection in those contracts that provide for compensation for delay in the event or an extension of time impact the right to prolongation often in many cases. But of course, if you get to an entitlement for prolongation established in principle, either by way of damages for breach or more likely by way of an entitlement following an extension of time, then there has to be a calculation of what has been the cost of the delay. And that can either be provided for in the contract by way of a calculation, a liquidated amount almost, an agreed amount per day, of cost anticipated and agreed, which will of course be subject to a Section 74 limitation potentially, or a calculation of how much more has it cost the contractor for being on site for the period of the delay. But I mentioned much earlier an example of experts working together effectively, where they agreed the cost of disruption. The calculation of claims for prolongation are simple compared to claims for disruption, because a claim for disruption is really a claim which may or may not be based upon a claim for breach of contract, but which says, because what you did to me meant that I lost effective productivity in the work I was doing, I'm entitled to be paid more for doing the work because it costs more to do the work due to the disruption I endured. In many instances, though, the disruption, or indeed alleged acts of acceleration, will relate to scope changes, which are entitlements of an owner to change the scope of what is being built. Infrastructure contracts are unique in many ways, in that they're not a contract to do a defined thing. They're a contract by way of marriage, which says, during the period of our relationship, I, as an owner, can ask you to do a whole pile more things that you never thought of. And you'll do them. But I'll pay you. And there'll be some calculations of how I'll pay you. Now that's an unusual contract, because the contract to buy a house, you buy the house, you pay the money. You're not able to buy two houses, but under a construction contract, you might be able to be compelled to build two houses instead of one, by way of the power to vary. And therefore, the changes that can validly be made under a construction contract need to be priced, and their effect calculated insofar as, for instance, beyond the cost of actually doing the additional work, there has been delay or disruption. And that represents a quite complex exercise. So I was amazingly grateful for and pleased that the proactive case management of the tribunal I was on the atomic power station, led to a calculation, because you can just imagine the difficulty of calculating the effect on the structure, on the systems, and on the way in which the mechanical circulation of cooling and other equipment within the thing were impacted by the changes. But it was able to be done, and the experts ultimately agreed on that. So that represents a canter, if you will, through the topic of damages in international arbitration. You have, though, some material in the books that are before you, in which a number of the issues that we have brushed across by way of explanation are dealt with in a lot more detail. So we hope that our presentation has provided areas which, if you are interested in exploring in more detail, you will find some more detail in that material to assist. But now I think it's time, if you have any questions, to discuss what we've raised.
Practice in the area of arbitration as counsel. You rightly pointed out that more often than not, it's very difficult for a tribunal to actually come to conclude what part of the prolongation is due to the employer or the contractor. Now, how is it that as counsel we can assist the tribunal in actually coming to a conclusion? Because without that, even if in principle you are able to assist the tribunal to conclude that you're entitled to some damages or some compensation, the exact amount will never be known. And without that happening, it's possibly impossible. It's almost impossible to get an award in any manner of quantum.
It's a very good question, and if I may, I might make an observation which you may disagree with, but which arises from my experience so far in cases involving Indian parties in these sort of disputes. And that is that there is less use in India in disputes of this sort of independent experts than one sees in other jurisdictions and more broadly in international arbitration generally. In order to answer the question of what compensation should there be for a period of delay, as you rightly identify, firstly, the delay attributable to the cause of action leading to an entitlement to payment needs to be identified. So that involves an assessment of the complex of what actually happened on the project and what was causative of delay that is relevantly compensable. There are experts who take up all of their professional life providing assistance to parties to try and calculate those delays. However, they fall squarely into the category that Janet was describing of experts who counsel would like to be hired guns. They're meant to present the delay calculation for the party who has appointed them. And it's in that area that there needs to be, and there can be in my experience, a real interaction between the tribunal and each party's expert to try and help with this. Because, as with calculation of damages in M&A disputes, there are different theories of how to calculate delay. There are protocols developed by the Society of Construction Law which try to assist in the methodology of calculation of delay. But there is nothing better, in my view, as an arbitrator, than actually seeing someone who's been on the site at the time things were happening, saying, this is what delayed me. All of the theory that is developed after the event from the project documents by the delay experts is useful, but needs to be supplemented by someone saying, this caused me delay. So it's a factual question of what actually caused the delay. If that can be defined, then the calculation of the cost is more simple, because there will be experts who can say, this is what it actually cost to keep the resources that were site-wide on the project for the period of time at the time of the relevant delay. That can be done, and the quantum calculation with care, working with both experts, can be done. But the problem that you face, I think, is that many of the construction cases run in India at the moment tend not to rely upon experts as much as cases elsewhere in the world. Now, experts are a blessing. They can also be something different. and they're expensive, which is why they're not always deployed. But I think with tribunals that can manage their deployment effectively, parties can save money and get to an outcome. It's a long way around to answer your question.
Thank you.
Hi, I'm Astha. So my question is also regarding the delay. There are clauses which say that in case of extension of time due to contractor's default, if there is imposition of LD, the owner can impose LD. However, in certain cases, LD is not imposed. Does that mean that the default is not on the part of the contractor, or still a delay analysis is necessary in certain cases?
Can you ask that again, please?
So I have come across clauses in which it says that if the contractor is at default and extension is sought, the owner can impose LD. However, LD was not imposed. So does that mean that the default was not on part of the contractor, or still delay analysis is necessary in certain situations?
So that's really an argument about whether, if at the time the alleged delay due to the default of the contractor occurred, LDs were not imposed, have they been waived, and are they subsequently able to be recovered by the owner who, faced with a dispute, is looking for its own rights to enforce? Is that what you're saying? Well, I think each of those cases depend on the facts. There can be waiver, but the principles of waiver would need to be satisfied, and there are certainly cases where there is a right to a liquidated damages asserted when they've never been deducted previously, which have succeeded. So I know it's a typical lawyer's answer of it depends, but it does rather depend on the facts.
You must have read an Indian judgment on that.
Yes.
What are the judgments say?
So it's still disputed that in an analysis it has been said that in case LD is not imposed, then maybe it's not the contractor's fault. However, I have been arguing that a delay analysis has to be done in that case also.
I think that I'm obliged to agree with him. It will depend upon the facts of the case.
If I may just add, in most of the standard construction contracts that you would come across, there would be a non-waiver clause. And I think just failure to impose liquidated damages, if there is such a clause at the relevant time, may not necessarily constitute waiver. But there could be facts when it could constitute waiver. It's just so fact specific.
It could also be that the circumstances in which liquidated damages were not imposed might go to assessing whether the actual alleged default was a default or not. A factual question.
Yeah, myself Adesh, and we are by profession expert who do delay analysis and a quantum analysis. Regarding that questions, what I would like to share our experience is that whenever we do the delay analysis and we prove that by the delay analysis it is a sole delay of the employer, then the LD is waived off. Otherwise, if it is a concurrent delay and the contractor is getting delayed, and if it is a delay responsible attributable to the contractor, then definitely the employer will impose the LD on that. But if it is a concurrent delay, they will give the extension of time but not the compensation part. Usually what we experienced with the EPC contractor and other contractor as well.
Yes, lady.
Hi, my name is Urvishi. So one of the study materials that you provided at CL number 8 deals with damages in construction arbitration. And one of the topics discussed are the costs that are incurred by the head office. And you've given 3 formulas. One is Emblem Hudson, and there are 2-3 other formulas discussed. Just wanted to check which would you pick and which would you apply depending on the circumstances, which is the best approach to it.
Well, because of the complexity of trying to calculate the impact or the recoverability of head office overheads on the actual cost of the prolongation of a project, these formulas have been developed to make it easier for the lawyers to work out what the calculations are. There are arguments in principle which suggest that if you apply basic principles of recoverability of head office overheads, there might be a need to demonstrate that the head office overheads were usefully deployed in the first place, and that they were likely, if they remained employed, to have produced some productive profit in any event. Those are the complications associated with the formulas, but the formulas, are shortcuts to an answer, and sometimes they're accepted in the interests of simplicity to get an outcome. They all, I wouldn't want to express a view on which is better than the other.
Yeah, my name is Yogesh. I just wanted to have your view. You have talked about Society of Construction Law Protocol. How much weightage is given to SCL protocol as per your experience in the international construction arbitration? Difficult?
There is some controversy surrounding the use of the SCL protocol in certain areas, including in relation to concurrent delay. I think you need, as an arbitrator, it's important not to form firm views until you've heard the argument in each case of how it is to be deployed. But just be aware that it is an attempt to establish some common basis for calculation of delay, which can be valuable. But there is no substitute, in my view, for someone who actually saw what was happening. I had a case, just as an example, quite a few years ago, involving a massive wastewater treatment plant in the Middle East. The contractor had terminated the subcontractor for bad performance, allegedly. And the question was whether they were performing with due expedition. Because if they weren't, they were entitled to be terminated, and if they were, then there was no basis for termination. As usual, there was no really useful program against which to assess performance, because there had been no agreed program for running the work. So 2 delay experts armed with SCL protocol assistance spent a lot of money presenting competing views about performance. One of the senior foremen on the project was giving evidence, and perhaps foolishly and certainly to the chagrin of counsel, I asked the witness what was really causing the delay on this project. And he said it was the waterproofing, at which point you could have dropped a pin and it would have crashed to the ground, because no one had mentioned waterproofing in any of the delay analysis. So I then said, well, whose problem was the waterproofing? Oh, he said it wasn't anyone's problem. It was just something that happened and no one was to blame. So at that point, I think about $1 million worth of fees from the delay experts went down the sewer, which the water treatment plant was meant to deal with. And we were left with the evidence of what caused the delay. So it was for me a very salutary lesson that it's absolutely critical, notwithstanding all the protocols, to actually get some facts from people on the ground. Yes.
My question is regarding the prolongation remedies that you referred to. In most of the cases, I believe in infrastructure contracts, more often than not, the reason for prolongation is both the employer and the contractor. While granting compensation to one of the parties, how do you determine the percentage of how much of the prolongation was caused due to the employer and how much of it was caused due to the contractor, and then determining the compensation or the penalty to be imposed? Thank you.
I don't think you can do a percentage calculation. It depends on what caused the delay when, which is why in my answer to the previous question I said, in order to get a precise answer, you need to have a calculation of what delayed what. Sometimes tribunals faced with inadequate evidence need to do a percentage calculation because it's clear that some delay has been caused in a compensable way by the owner, but that's not a really satisfactory way of getting to the answer, and I don't think a percentage method is terribly accurate.
So Hudson formula is not accepted.
And I'm sure we've all learned a lot today. Just as Sir said, we'd all be leaving as better students from here. I would now like to invite Mr. Gaurav Pachnanda, Senior Advocate and Director of NPAC, to deliver a vote of thanks.
Thank you. Thanks a lot. As Professor Jones indicated, India is a jurisdiction with its own peculiar legal issues. The civil trial over the last 3 or 4 decades in India has seen a steady decline for several reasons, including the clogging of our court system, as a result of which the volume of judicial precedent on issues of commercial law that we see regularly has gone down significantly. But there is an institutional response to this problem, and over the last two decades, we started off by coming up with a robust arbitration regime that's very vibrant now, meets with international standards. And then we now have a very proactive commercial court system in India that's coming up. But when you look at this entire scenario in the context of what we have, there are gaps in jurisprudence relating to commercial law issues, just because of, as I said, just because of the manner in which historically our system has developed. And it is in that context that today's discussion on damages and principles for award of damages is of great significance. It helps practitioners and all of us students here attempt to fill the gaps in our knowledge, particularly in the context of how these issues are looked at internationally. We are very grateful to Justice Mishra for coming and